This is another bench. This is relating to Foreigners Act. McLeod. This is the trial court, I think. This is the trial court. এখানে before the special court under NDPS is Jaigar. Write it before the additional and session judge. The additional district and session judge. Make legal. Correct. দিয়ে দাও ওই লাঞ্চের সময় করে sorry because of this your client could not be released. We are coming after 5 minutes. Not before this page. Hey, here. Wow. What is the application? What's the reason? We are disposing of. We are disposing of the application we have argued. We have taken out of turn. No, no. Arguing today itself. You were arguing. Why? No, no, no. We are disposing. Unnecessarily why? If we are not satisfied, unreported. That was sitting with whom? My brother is differing with that. Yes. Application would be taken up on Friday. Why you are mentioning the matter? Don't underestimate the pace.
Item number 91, that you also directed to settlement that already arrived and application was done. My has been filed. So it's matrimonial, I become Monday to that thing. I don't know. I forget.
Yes. Good sense has prevailed. Monday has to be mentioned.
But observation meaning the order should not create that said that only that
Clarification, give the application.
get that one
It will be taken up on application day. Don't worry. Application day is tomorrow. It will be taken up. It has not been done.
Yes.
Yes. Yes, we talk. Before vacation.
But there were three items, but all of us assigned to Bala. Bala related to the matter. Government chief said he has sent all the matters.
It will appear as to be mentioned. We'll
But
fix
before
it.
there is to be mentioned, so that all the parties are.
Yes. Hey, you know,
Suspicious maybe from the since that manner. The matter on the last occasion, after the subsequent.
tomorrow mentioned. Give. Yes.
Yeah,
Application. Is a content or it's not a content? So it will be taken up. Application is
yeah.
whatever it will be taken up on Friday. Don't worry. Come ready, and if at the time of call nobody is there, out of list. Remember.
Yeah, my last time being. A matter below, the matter was appearing before your lordship, considering the other matter was taken by bylaw justice. Decided by bylaw justice. Matter was sufficiently hard, Lord.
Go before that. A to be mentioned for rupees. Correction. Here. A justice I to put this. To correction. ফাইল পোর্ট প্লেয়ারে ফাইলটা আছে আনিয়ে নাও যদি কালকে আনাতে পারো সামনে সপ্তাহে আনিয়ে নাও yes
Item number one.
One.
On 12th of July,
Why release? Why we release?
No, there was a. That was 2000.
But these matters have been assigned by the Chief Justice. Spain. To stop. Did these second appeals be listed under order 41 rule 11 procedure on Monday? Feature number 3.
Responded matter.
Madam, please go ahead.
Not today. Not this week.
Or
Yes.
extension.
The accommodation is sought on behalf of the respondents. Matter has come up for extension of entry. The interim order is extended for a weeks from date or until. This is the matter immediately after the long vacation. You know. Yes, thanks. You know what is the specific? What is this specific fixed matter? Why? Actually. Put the down. See that.
Okay. That represented by
And your lordship will find that the document has been taken back as I found from the certificate copy. These are the seal envelope which has been sent by the learned advocate on behalf of the plaintiff to my client. And I have opened one, others two I have not opened. Kindly see this. Whether it contains the death certificate or not. It is sealed, my lord, I have not opened.
না একটা খোলো ওটাই শুধু খোলো
May I just see once the record, my lord? Because it is sealed because I could not.
দিয়ে দাও
Record the down.
এই রেকর্ডটা দিয়ে দাও ওটা নয় এটা ওটা ওটা খোলো না
এখানে দেখুন।
ছেড়ে দাও ওটা খোলো না আচ্ছা Why did our calculate? I'll share with you.
But your lordship, here, my lord, it is not there. Now, my lord, kindly see the my lord, the document which has been supplied. Because I have opened only one envelope, and
Yes,
others, my lord, I have handed over to your lordship.
May
May I just give one?
I? So, একবার দেখি আবার। Super options.
The plain page 31, your lordship will find the indication of date of death. Paragraph 4. ওটা ছিঁড়ে যাবে, ছেড়ে দে।
ছেড়ে দে, ছেড়ে দে। See, the disclosure of a documents to be relied upon. See. Job. Close করতে হবে।
But if you lordship see my application,
দেখতে তো দেবে। ঘটনা ওটাই আমি দেখতে চাইছি। সেটাই আমি দেখতে 42 এবার 42 এখানে 41 করেছে এটা 40 করেছে 39 23 আমার বাড়ির নাম্বার 23 চালাচ্ছি
Kindly see the PAN card. And this PAN card has been prepared in 2023. Aadhaar card, date of birth 1970. Year of the birth is 1970. PAN card prepared in 2023. And in my stay application, I have specifically stated, I have not stated that the document was filed in the court below, that was supplied. Kindly see once my stay application, page 9, paragraph 6.
reflection. There's no reflection. Reflection. That's right.
And in kindly see PAN card, the name of the father. Kindly see once the PAN card. I think that is, my lord, with your lordship's record.
I leave it to you.
Before passing any order, kindly see paragraph 9, page 6 of my injunction application. Because I know this will be happening, and for that, kindly see my application for injunction. And your lordship will be surprising this PAN card has also been procured, because in PAN card, kindly see, but this is normally it is issuing by the central. Kindly see the father's name. Paresh Chandra Sen. If a person died in 1964,
Aha, we understood that 1970, how can? But now science has developed, advanced.
now, my lord, unless we give some document, suppose we write in the PAN card that my father's name is such and such, they will verify. Not that by closing their eyes they will issue. And my lord, kindly see, I have specifically stated, my lord, paragraph 6. Kindly see my application once, my lord.
Very interesting. After 2002 amendment, it is a mandatory that when you file a plaint, you have to give a list of documents. If you do not give a list of documents, then you will not be permitted to rely upon those documents at the time of trial. And there is a complete absence of any disclosure of the documents. We are going to say that these kind of a practice, that by filing a Firisti and then not including anything there, because I find that your Firisti says only 3 documents. That's all. One is the first one is a notary, second one is a deed, third one is Aadhaar card. If only 3 documents, then how PAN card came here along with the Firisti? You did not disclose it. That shows that there was a certain document, that is a document which was also there. You purposely did not include it there. How the PAN card came, which is not reflected in the Firisti? How it came? And you boldly submitted on the last occasion on instruction of a client. I mean, your client boldly said that I never filed it, I never know.
Who is the
I
client?
am not in possession.
Who is the client? Let her appear. She will say everything. This power of attorney holder is the mastermind.
We are calling this lady to appear before us. We will not leave the matter in this way. Pursuant to the order dated, the record pertaining to title suit number 526 of 2023, filed before the Civil Judge Senior Division Second Court, Baripur, is brought before us. We had an occasion to peruse the record of the said title suit, which contained a Firisti allegedly filed by the plaintiff respondent, containing the description of the document annexed thereto, wherefrom we do not find the reflection of the death certificate issued by the Gram Panchayat recording the death of Harish Chandra Sen. It is important to note that immediately after the ex parte ad interim order of injunction is passed, an application is taken out by the plaintiff respondent to take back the original documents. And the trial court mechanically allowed the said application with the direction to replace the same with the photocopies, with the photocopy thereof. It was contended by the plaintiff respondent on the last occasion that his client never filed such death certificate, and therefore the question of possessing the same does not arise. Obviously, there is no reflection of the death certificate issued by the Panchayat in the Faristi filed before the trial court. But we also notice that there is no reflection of the PAN card in the Faristi. Yet the photocopy of the PAN card is found to be a part of the Faristi. It is a duty of the filing department when such Faristi is filed to verify the documents, description whereof is given in the said Faristi, and if there is any discrepancy in this regard, should immediately point out to the advocate and record who filed the same. And in the event the same such discrepancy is not remedied and or removed, the documents contained in the said Faristi, any document contained in the said Faristi, the description thereof has not been shown, shall not be considered for any purpose. It is a matter of great concern that the plaints are filed. The plaint is filed in the trial court without disclosing the documents sought to be relied upon in the said suit. The filing department in the trial court must be sensitized in this regard. And in the event the same is not in conformity with the provision of the court's procedure, shall record such defect and invite the advocate and record of the plaintiff to remove such defect within a time frame. In the event the defects are not removed and the time is not extended by the court, such plaint shall not be deemed to have been presented, though filed, and consequent thereupon, any interlocutory applications taken out therein should not be allowed to be moved unless such defect is removed. The counsel for the appellant handed over 2 sealed postal article which is received by his client, and invited the attention of the court to verify whether there is any whether the documents contained therein whether the documents contained therein includes the death certificate issued by the Gram Panchayat for Harish the same. It is indicated that 3 postal articles were served upon his clients, who are obviously 3 in number, out of which only 1 postal article was opened, and the photocopy thereof is annexed to the injunction application filed in connection with the instant appeal. We opened the other postal article and we find that the death certificate issued by the Gram Panchayat is annexed to the application for injunction. A practice has developed in the court below that they've developed in the court below while filing the application for temporary injunction, which does not contain any annexures. Even the averments does not indicate the documents ought to be relied upon in support of such averments. And what is usually done in such cases is the filing of the documents separately along with the Pharisee. Such procedure is unknown, though prevalent for a considerable period of time. Any document sought to be relied upon must be annexed with an application for injunction, at least to be a part of the affidavit, and therefore the person must owe a responsibility of genuinity, authenticity, and the sanctity of the said documents. We therefore feel that a direction must be passed upon the trial court. Now, we therefore deprecate such practice prevalent in the trial court, that the documents are filed along with the Pharisee without any reference as annexure in support of the averments made in the interlocutory applications. We therefore pass a direction upon the Registrar General to communicate this order to the district judges, to district judge of all districts, to follow the rigor of the code of procedure. I will give you all these provisions. Henceforth, and shall not permit the filing of the documents which does not become a part of the said application. In support of the contentions, in support of the averments made in the interlocutory applications. It is to be borne in mind that the application for temporary injunction is decided on an existence of a prima facie case, apart from balance of convenience and inconvenience and irreparable loss and injury. It is while arriving at the conclusion, which obviously is prima facie in nature, that a tribal case is made out, the court proceeds to decide it on the basis of an affidavit evidence, treating the documents annexed thereto to have some impact on the claim and likely to be proved at the time of trial. It does become more necessary that all such documents must be annexed with the application for temporary injunction to be a part of an affidavit affirmed by a person, and not in the manner as we perceived in judicial dispensation. There appear the prima facie, we are of the opinion that the next paragraph, the stand of the respondent is not correct. After noticing that the said death certificate is annexed to an application for injunction. And therefore, we call upon the respondent, the plaintiff respondent, to appear before us personally to explain her conduct in this regard. It goes without saying that the learned advocate on record who appeared before the trial court shall also remain present on the next date. In this regard, the counsel for the plaintiff respondent appearing before us is directed to communicate this order to the advocate on record of the plaintiff in the trial court, who and as well as the plaintiff respondent herself. Let the lower court record be kept with this file. List the matter on Tuesday
Alright.
to be taken up at 10:30.
And let this envelope be kept with the record, which I have supplied to you.
Let two envelopes filed by the appellate, out of which one has been opened on direction passed by this court, and the other in a sealed manner, be also kept with the record. The ACO cell keep those envelopes in a bigger envelope, duly sealed, so that it may not be accessible to either of the parties or their counsels.
Great.
Not returnable Tuesday at 10:30. But instead of 10th, can it be on? Or can it be on Thursday? Why? What is the difficulty? You have tomorrow, you have the weekends, very easy to communicate. Then Monday, sufficient 4 days time is given. Weekend is more convenient to contact. Because in the British busy schedule at the court, some may not find time to contact. Now, weekend is the best time. Yes. Can it be on Wednesday then? Tuesday. What is the difficulty on Tuesday? Just tell me. What is the difficulty? We do not know about. Your advocate in record knows who is there. Your advocate in record knows the party. Through power of attorney holder. I do not want. I want the power of attorney has to be communicated to ensure the presence.
No, 10 minutes আমাকে বলা হয়। I just said that you could get
Copy গুলো থাক করে নেবো, থাক করে নেবো। দেখাচ্ছি, আর সেটাই তো থাক করেছে। কি তো বলছি দেখাবো।
Not without it. This is what. Yes.
ছ নম্বরটা দেখেছো? 6
Yes, call.
well, not so far I am concerned. Virtually I finished, but I'll take today only 10 minutes time because my lord has given much intelligence to me to argue this case for 4 days. I don't like to spoil your valuable time by repeating. I just want to draw your lordship attention to one aspect. Even in the commercial proceeding, my lord, there is now it has been introduced by the Commercial Act. There is a provision for mediations. Before a party approach the court, they must make an attempt. Obvious reason in his wisdom, is a thought that well, before going to the court, try to settle yourself. But here, my lord, is a burden on the court. I should say burden. It's a duty of the court as per Supreme Court judgment, my lord, that well, all attempts should be made because this is not a commercial transactions, especially the fate of a offspring are involved, which is fate of the offspring are involved because they are actually the worst sufferer. But anyway, I'll just cite one judgment, my lord, of the Supreme Court, where Supreme Court is clarified what is to be done, what is not to be done. So, my lord, kindly take trouble to this judgment. Third judgment are there.
On what proposition of law?
Let me place, my lord, and I'll explain.
What proposition of law?
That's mentioned here. I'm kindly see, my lord, that is mentioned here. I know, my lord, I'll ask these questions. That's why I draw your conditions. Law that has been laid down by the Supreme Court with reference to a law of the Court of Civil Procedure. Kindly take trouble to come, paragraph.
On what proposition? Section 89 of the CPC or what? On a mediation or what?
32 capital A. That's why I'm asking, I'm requesting your lordships, kindly have a look to the judgment. I know, my lord, ask these questions, but answers will come out from the judgment of the Supreme Court itself. Supreme Court has clarified the positions, the power of the court. Kindly take trouble to the judgment, which is handed over to your lordships, my lord.
Yes.
2007 2 SC Supreme Court cases, page 564.
Yes.
Well, this is also in connection with the matrimonial case, my lord, paragraph 12, 13.
Oh.
I'm reading, my lord, with a logical. Special provisions have been made in the Code of Civil Procedure, Amendment Act 1976, in respect of suit relating to matters concerning if the family. In Order 32 capital A, Rule 3 of the said order requires the court to make efforts for settlement of family dispute. The said rule reads as follows. Duty of the court to make efforts for settlement. In every suit or proceeding to which this order applies, an endeavor shall be made by the court in the first instance where it is possible to do so consistent with the nature of the circumstance of the case to assist the parties in arriving at a settlement in respect to the subsequent of the suit. If any such suits are proceeding at any stage, it appeared to the court, at any stage appeared to the court that there is a reasonable possibility of a settlement between the parties, the court may so adjourn the proceeding for such period as it thinks fit to enable attempt to be made to effect such settlement. The power conferred under Subrule 2 shall be in addition to and not in derogation of any other power of the court to adjourn the proceeding. The Act, Hindu Marriage Act 1955, is a special act dealing with the provisions relating to marriage, restitution of conjugal rights, and judicial separations, as also nullity of the marriage and divorce. Chapter 5, section 19 to 28, capital A, deals with jurisdictions and procedure of court in petitions for restitution of conjugal rights, judicial separation, or divorce. Subsection 2 of section 23 expressly states that where a petitions for divorce is filed under section 13 of the Act on certain grounds before proceeding to grant any relief, the court in the first instance should make an endeavor to bring about reconciliations between the parties. Then paragraph 16, my lord, which is very relevant. In the above decision of this court, make it more than clear that the approach of a court of law in matrimonial matters is much more constructive, affirmative, and productive rather than abstract, theoretical, or doctrinal. Matrimonial matters must be considered by courts with human and sensibility. Which is very, we said that the basic and fundamental difference between commercials and other suits and the matrimonial suits. It is not a journey from Howrah to Delhi. It is for all time to come. The couple will be run side by move side by side. If anything is happening, the court is the guardian. Court must say, no, what I see left to obey. Even that was happening in other court, my lord, that will know. Mediations is our pleasure. You have no right to poke your nose. We will try, because duty has been casted on us. I'll have to discharge. Apart from other things, my lord, as rightly observed the Supreme Court, matrimonial matters must be considered by courts with human moral and sensitivity. Delicate issues affecting conjugal relations have to be handled carefully, and legal provision should be construed and interpreted without being oblivious or unmindful of human weakness. My lord, what actually happened between the couple, nobody knows. Even the parents, they do not know. But the court can crack the cell and look into this for the welfare not only of the child, but also for the couple. Because sometimes they are fighting unnecessary, fighting of ego, fighting other things. Court is the guardian. Court can see, no, what you are thinking, what you are doing is not correct approach. We are here to protect you. Don't do that. That right is vested to the court, and court is a supreme. Court can do like this. Even in the commercial matters, this is free. And here, my lord, something more. At any stage of the proceeding is wisdom of the court, because it is a social aspect. And commercial court, my lord, prior to litigations, my lord. But here, even after at any stage of the filing the suit, courts, if the court thinks, no, what for we are here? We are not the social reformer, but we must see that, well, the fate of this offspring is not spoiled. What the friends and the other guardian will see when you go to the school? Oh, your father and mother are living separately, and everybody is spoiled basically, my lord. And they get at his pleasures by saying all these things. So that's why my humble submission is, my lord, that, well, it is another aspect, major aspect to be taken care of. Then, my lord, oblivious, mindful human weakness. Probably the aspect has been kept in view by the legislature in enacting subsection 2 of section 23 of the Act by requiring a court to make all efforts to bring about reconciliations between the parties. Sometimes they say what they are saying, that is the last word. No, it is not the last word. Last word of the court. In a democratic setup, my lord, the court word is the last word. Nobody can see it over there. So that is why, my lord, legislators only wisdom thought it fit that, well, there must be specific provisions. Otherwise, there will be some sort of confusions. Sometimes some court may say, no, you don't have any authority or jurisdictions. Consciously, simply that particular provision. Very rightly, my lord asked me the questions, where is that provisions? But this is actually provisions which has been dealt with in details by the Supreme Court, and Supreme Court found it should be done. Before more than 4 decades, such and such case, myself, there can be no doubt that the duty is laid on the court to make every endeavor to bring about a reconciliation between the parties whenever the nature and circumstances of the question permit. So, failure to the trial court to make such efforts does not mean that appellate court at a later stage should not undertake such exercise, because it's a continuation of the proceeding, my lord, notwithstanding any legal aspect and other things. If the court thinks, but at the same time, I must frankly confess, my lord, judges are also human beings. I have seen, my lord, some judges, maybe in personal life, they have got some problem. I'm not saying anything. Oh, you are asking for divorce. All right. Some judges make an attempt. No. Merely you are asking, I will not do that. I've got something to do. And that is actually an empowered by the court. And court has give the power to the court. It's a continuation of the proceeding. Law doesn't mean to be a mere theoretical abstraction. It is an instrument to the justice, and you are here to have the justice. Sometimes the people, the persons who is asking for justice, he doesn't know how to say the case, doesn't have any idea. But court is very conscious. Court is keeping his eyes open. No, we are here to see whether really proper justice should be done or can be done here. The intention of the provisions undoubtedly is to render all possible assistance in the maintenance of the material in the marital bond, and if at any stage of the case of the circumstances are propitious for reconciliation, it will be the court's duty to make use of the circumstances irrespective of the stage. Why I am saying this? Certainly, my lord asked me, Mr. Manager, that is at the first instance, even if it is not done at the first instance, because ultimate object is to give justice. And that is the last word, my lord, justice to be done. And how and which manner to be done, court is the best authority to consider it. It's not me or even the persons who are knocking the door of the temple of justice, because they do not know, they are blind. Sometimes they do not know what is good, what is bad. Many reasons they are fighting against each other. And unfortunately, they do not care for the offspring. I remember, my lord, that well, a kid, my lord, know the story of Napoleon, my lord, is very Napoleon. A wrong route means 16 years old, they are actually sending to the war. There's a war between France and England. Now, my lord, a wrong route was arrested by the French soldiers, and he was sent inside the war. He made an attempt to cross the door with a drum. Obviously, he was arrested. He was taken to the Napoleon. So Napoleon asked this boy, why did you make this attempt? You know, you won't be able to do that. What are we to do? My mother is waiting for me over there. I cannot bear separation from my mother. That compelled me to make that attempt. So please consider. I assure you, my lord, I'll go over there and again I'll come back. Napoleon just waited for 5 minutes. Yes. Colonel, come here. Take this boy and send this to his mother. Kindly see, my lord, this is the whole thing to be taken care of. When the boy will go to the school, will go to the social gathering, inevitably other will pinch him. And that is our conduct, unfortunately. There is a saddest pleasures. There's a misfortune. To forgive of that, and as a whole, my lord can convince them. Ask them to come before lordships. They must appear before lordships with the carcase. What's the problem with them? Let them come before lordships in camera. Even the lawyers shouldn't be permitted to go over there. No advisors should be there. Kindly take trouble to go, take trouble that ask them, come before me. After that lordships, whatever lordships things fit, it will be done. Then, my lord, the court make the effort does not mean that appellate court at a later stage should not undertake such exercise. The High Court of Patna held the subsection 273 of the Act enjoins upon the court a duty to make a sincere effort at reconciliations before proceeding to deal with the case in usual course. It was observed that in order that the requirements of making every endeavor is fulfilled is at the least requisite that the court should have a first-hand versions. Such first-hand versions obviously can be had if the parties are present before the court. What I am saying, sometimes it happens, my lord, they don't disclose everything to the lawyers. It happens. But before the process, my lord, first take individual interview, then jointly, then along with the kids. Let the truth come out. What has happened? What we have seen? Now, how's our parents and other things? There are 1,001 quarrel and other things. Still, they spend their life happily. How's it? The reconciliation proceeding really had led to the then a perusal of subsection 23 of the Act leaves no room for doubt that even where the chacham between the parties, kindly similar, a settlement between the parties to the marriage might seems to be acute. It is a duty of the court to make every endeavor to bring the parties to reconciliations. Of course, the court cannot help if in spite of his endeavor, no reconciliation can be brought, can help in spite of such, but every endeavor in this sense. So I can take the horse to the spring, I cannot compel the horse to the ring. But to take the horse to the spring, it is only the court can do that. And I am sure they will drink water. If the court really sincerely make an attempt that, well, what you are doing is not fair and proper on your part. Enough is enough. Go and enjoy yourself. And still a long way you have to go. It is not a case like this at the coastal reputations. Both party purchase ticket to go to the Delhi, from how to Delhi. After that, nobody knows each other. This is not a case like that. As I am told, Momo is a as I am told. Have I ever said? I said the influence are derived from my lords. I'm sorry, sir. It's the duty of the court to make every endeavor to bring the parties to the directions, go to the meeting. Then my lord, ultimately my lord court made an attempt and that was done. So this is the whole case, my lord. I have read the inter judgment. I need not disturb your lordship. The judgment, inter judgment is discussed thoroughly. And court says, yes, we can do that. And it is irrespective of Article 142. Because Supreme Court says, my lord knows within my lord, Supreme Court has a special power. I remember in one instance, my lord, it was before Justice Kurian Joseph in a bench. He presided the bench, my lord, with other two judges. This morning purchase, he was taken to the Supreme Court. I filed a contempt application against him. So they will not give service to my clients. There were 62 persons. Mr. Kurian just said, Mr. Banerjee, you take it, I'll take care of it. No problem. I know how to tackle the situation. And who has done this mischief? Oh, you are here. Come on. I'm giving you a fortnight time. And bring all the appointment letter and hand over to Mr. Clients. Mr. Banerjee's card. Well, not to me, to my clients, yes. My lord, there is no provision. His counsel started arguing. My lord, there is a provision. Provision is there, but Article 142 is also there. You have a special power. Saying the matter is there. And before this, when normally Supreme Court, my lord, bench varies. This bench will hear this matter. If you do not comply that, I know how to tackle the situation. Matter was complied with, everything was done. But here, consciously, statute in his legislative wisdom thought it fit that power, special power to be given by the court, by incorporating the court itself, with the blessing of the court, it can be done. And legislature was not blind. Whenever the law is framed, we say an object, purpose, reasons. What are the reasons? Because it is a social aspect. So all attempt to be made, they can say so many things to the others, but they not dare to ignore. They not dare to say anything against your lordships. It can't be. So my lord, this is the situations. I'm grateful, my lord.
আরেকটু add করতে হবে।
Content. Mr. Basu, you want to add something, my lord? My,
May I add? With the leave of my senior.
no, no. do
Or you
what-
lordship will come back. But this judgment has been rendered under Hindu Marriage Act. But
The
I
similar
want to,
provision is
I want to show to your lordship, my lord,
the
in
same
the Special
provision is-
Marriage Act, under section 34, a duty cast upon the court before passing decree, which, my lord, in pari materia with the Hindu Marriage Act, it says language is before proceeding to grant any relief under this act, it shall be the duty of the court at the first instance, in every case where it is possible so to do, consistently with the nature and characteristics of the case, to make every endeavor to bring about a reconciliation between the parties. So not only one article order for 32 capital A, rule 3, this statute itself has given cast a duty on the court. It is not, my lord, the parties has nothing to do. The duty on the court to see the marriage is saved. But here, my lord, can you see in the facts of this case, on the particular day, everything done. So I submit before my lord, before going to that ultimate conclusion of divorce, separation, but court should have given an endeavor whether the marriage can be saved. This is the intent of the legislation, to save the marriage. Then, my lord, this is on that point. Secondly, my lord, whether if the grounds are not there, whether, my lord, court will pass a decree. My lord has ample number of judgment has seen this irritable breakdown. Everybody is clamoring, this is irritable breakdown. Can he give a divorce? In every time, your lordship's court, Supreme Court said, Supreme Court can under a separate power. High Court said, yes, I find that the marriage has been broken down. It cannot be revived. But the statute has not given that power to grant that relief. To that proposition, my lord, I want to cite one judgment for your lordship consideration. Reported in 1999, volume 2, Calcutta High Court notes.
Only
199.
question is who? What you are saying, all proposition of law, two settled proposition, nobody can dispute on that. The first and foremost and the core issue is
At whose instance?
who can come and say it is not in accordance with it?
But if the judgment is, my lord, erroneous, illegal, and it is brought to the notice of the court, the court will shut his eyes also. If it is nullity in the eye of law,
It's an appellate power.
that's I'm submitting. Your lordships can,
Appeal is a creature
Creature
of
of statute.
statute.
yes. And then comes in who can approach. But if after a approach, it appears to my lord that the decree is a product of nullity, whether even then, my lord, the division bench will shut his eyes. This is the, my lord, precise thing your lordship has to decide. But I am relying on 1999
That the
volume
court
2.
should follow the procedures of law. Any infraction will make it a nullity, will make it an illegal order. No quarrel to this.
No, that I want to keep this thing on record. my lord.
Only for the purpose of multiplication.
No, this is the two judgment. This is two proposition. One is that.
Yes. Anything more?
But another judgment I want to cite, my lord, 1978, one Supreme Court cases.
Yes.
Page 58, paragraphs 14 and 15. More or less on the same proposition, the court, prior to coming to the conclusion of passing a decree and order, must satisfy that the grounds for passing the decree is subsisting, is there.
No doubt about it. Again, I am saying,
Yes, yes.
going to a square one situation.
Who? I say, my lord, if I have brought this,
And these are two interchangeable, the words, the alphabets can be changed. who and how, all alphabets, only position is changed.
But I am giving this, try to demonstrate that if today I have brought this before my lord, a decree which is a nullity is before my lord. Even then, my lord will start your
That is
lordship
that is
size.
what I'm saying, that who and how the court will.
No, my lord, but I don't make myself clear. I bring it to my lord. It is before my lord. My lords observed, seen that this is a nullity. Document is a nullity. Even then, my lord will start your lord is only on the ground that who bring it.
The gentleman on that side was sitting in a trial court and was listening one case and found that the judgment was delivered by this. He will come and brought to the notice of the High Court. Look, this judgment is
No,
passed.
that
So
is too
the
broad a proposition.
court find High Court there is a nullity, absolutely nullity. The court will interfere and set aside. He's a lawyer of the
No.
court.
We
He
are,
has every right
I am
to
the,
bring it to the notice
I am
of
the
High
part, I
Bring
am
it
the
to
party
the
to the proceedings. I am a party to the proceedings.
That is why I say
This a stranger and a party to the proceedings are I think
same thing. Here's
no.
he says that I am affected because I am a law professional. I wanted the law should be declared in a proper manner.
This is
He has a right to prefer an
broad-
appeal.
too broad a
Prefer an
proposition.
appeal.
My lord is
This is
stretching.
what
My lord is stretching.
we have to stretch it in this
It's
way.
too far. But I am saying I am a party to this proceeding.
Say that whenever whoever has brought to the notice,
Not whoever, a party to the proceedings.
whoever
I am a
means-
party to the
let us see party to the proceeding.
I am a party to the proceedings.
Nullity.
This is my submission. My lord is to judge whether, in spite of looking to this, that this the order.
I wanted to hear Mr. Mukherjee more keenly.
No, that is in separate aspect.
No, that's true. More keenly
Yes, certainly. That is on.
because he has to satisfy both aspects.
Yes.
First thing is whether the right to the leave to prefer an appeal at the behest of somebody else apart from
Again,
parties to
somebody else.
apart from parties to the institution, whether he has a right. First,
He is right affected.
more
he can.
sentimental, no doubt about it. More sentimental arguments would be advanced in this regard. And secondly, let us see whether such challenge can come.
Yes, my lord. Kindly come back. Mr.
So,
Mukherjee is there.
This is what I wanted because the proposition which you say, same thing. When I said this, when you say that whoever, the party to the proceeding brings that it is a nullity, you have restricted. Here is not a party to the proceeding.
But he is affected.
That's why I say a lawyer.
Lawyer cannot be affected of a.
What are you saying? He is a protector, I think the preservator.
This
He
argument.
is to see that the law is respected and is decided correctly.
This argument, my
He
lord.
just says the nullity. How can you? You
I
did
will
not
take the cue
notice
from my
the
lord and
Supreme
argue
Court
some
judgment.
matter.
You did not notice the Supreme Court judgment. You did not notice. All these trial court judgments are bad. He can come and say that this is not a correct.
I will take the cue in some other matter. I will argue this. Borrowed from Justice Tandon. That I am a lawyer, so I am affected.
No, analogy can be drawn.
My lord, analogy. This
Same thing.
is
They
too
say whoever.
My lord is
Same
stretching too
thing.
far.
Same thing.
A person is affected.
Then
His
the
mother-
father of a girl or a boy will come and say nullity. Mother of the girl and boy will say nullity. Even both the parties have accepted. Suppose a
I am not
situation may come.
accept.
I'm again saying the situation may arrive, but both parties are settled with the divorce. But the parent found it's a nullity because not a single judgment of the Supreme Court which says otherwise has been considered or has been held against the decision of the Supreme Court. Nullity. Can't. It has to be reopened immediately.
My lord, come back. Mr. Mukherjee is waiting.
I think Mr. Mukherjee has a lot of,
I've seen
the
last
thoughts
2 weeks.
thoughts which has already been percolated very clearly and vividly.
I'm waiting, Lord, kindly come back. I beg that's it.
Yes. Okay. Although it a matrimonial case.
Every service.
You know,
Not be made live streaming. That is why we do not do it. The system officer did not know, rather we also forgot, but realized that it should.
Condition for stay.
Mr. Bose
So-
will move the entire appeal.
No, because I'm preliminary objection, I'm entitled to be heard.
No,
first.
I had addressed your lordship on the appealability. Your lordship wants to hear it again.
Let him, because by passage of time, something,
No, I was addressing your lordship on the maintainability of the appeal. He had taken a preliminary point that the appeal is not maintainable under the
so
commercial
let him,
code.
that
let
is
him
what I'm
say that
trying
why
to
it
tell
is not maintainable.
Why
then
it is
we'll
not
hear.
maintainable?
Yes.
Then your address is not maintainable,
So
whether
this
your
was-
appeal is
This
maintainable.
was an application under section 36.
Correct.
For stay of the award, and the order is passed. Against that, you say that appeal is not maintainable.
Maintainable.
Why?
My lord, because this is an appeal, the only provision for appeal under the Arbitration Act is under section 37.
And
37 does not contemplate
contemplate
any appeal from an order passed under section 36.
6.
The appeal lies from specific orders.
Correct. That is
Then
the only
That is
point.
number 1 point.
Yes.
Number 2, no latest patent appeal is also maintainable. We
Correct.
relied upon the division bench judgment of this honorable court following the previous judgments. That is also probably in your lordship's brief, where this specific point was dealt with, and it was held that no latest patent appeal under clause 15 would also be maintainable.
Yes.
So this was in the case of APL Metal, a
Which
coordinate
one?
bench of this honorable. Yes.
Yes. No, I got it. We got it.
Yes, yes. Stating a senior. Ye dekh copy.
You want to see?
Actually, he has addressed the bench. on-
APL আছে তো। Yes, then
My lord, after considering all, it was held that no appeal would be maintainable. Same order, furnishing security was the impugned order before the appeal court.
yes,
All judgments, including the judgment of the Supreme Court in the case of Satappan, as also was considered.
yes,
2004-11 SCC, which considers the latest patent appeal theory when there is a appeal mechanism provided under the special statute.
yes.
And my lord, the Arbitration Act
Yes.
And if your lordship will see this internal page 2 of the report, section 37 of the Arbitration Act has been
No,
set
that
up.
has been quoted.
Mine,
I have
mine,
seen the
yes.
section 13, then latest patent clause
correct.
15, everything I've seen.
Absolutely, absolutely.
So the court has ultimately held that when there is a a special act providing a mode of appeal or a right of an appeal, then it necessarily excludes the other general law. That's the proposition.
And my lord, it also takes into consideration section 13 of the commercial code.
That is what I said. Section 13 was also taken into consideration. It is
Right.
quoted here. Don't worry.
That's
It is quoted. So let us hear
all yours.
on the locus first, on the maintainability.
My lord, the fundamental question, consideration of your lordship is, my lord, respectfully, my lord, on two grounds. One is that, my lord, when an order of stay is passed in respect of an award, is that order passed under 36 or 34? My lord, kindly have, my lord, the impugned order once. That, my lord, your lordship will find in volume 3. And kindly have page 384.
No, we can have from the memorandum.
From the memo also, you can,
Yes,
you can take it.
memorandum we can have.
Take it
It's
from
a
the,
one-page order. There's no difficulty. Two-page order.
yes, my lord, it's a very short order.
Yes.
Heard learned counsel appearing on behalf of the parties. This is section 36 application.
Correct.
Award dated so and so is for rupees 4.5 crores along with interest at 12%. Mr. Bose appearing on behalf of the award holder submits today the award stands at approximately 8 crores 11 lakhs. Then, my lord, kindly turn the page over. I am of the view. So, my lord, unreasoned award, unreasoned order. I am of the view, straight away I am of the view that the award debtor must secure the entire awarded amount along with interest. The award will be stayed under the following circumstances. Award debtor is directed to deposit so and so. So, my lord, the terms are laid down. So, my lord, although, my lord, one of the first contentions and the merits, my lord, is that it's a completely unreasoned, unspeaking, or non-speaking order.
No.
I have to cross the threshold
Correct.
of appealability. Now, my lord, kindly take section 36(2) of the Arbitration Act. My lord, it is our contention
Commercial Courts Act bar koro.
my lord, even before inviting your lordship to 36(2),
Commercial Courts Act bar koro. Here it arbitration pe geche.
my lord, may I hand it up, my lord? May I hand up 2 copies?
আমার একটা আছে, তোমার দুটো আছে।
আমার দুটো আছে।
এখানে আছে।
আছে,
একটা সাইডে দেখে দাও লেটেস্ট পেটেন্টটা বার।
My lord, may I hand up 1 more copy, my lord?
এখানেও বার করে দাও। দাও আমি বার করছি। এখানে দাও। এটা লেটেস্ট পেটেন্ট দেওয়া হয়নি, এমনি অরিজিনাল সাইটে তো দেয় ওরা বইতে। Yes.
My lord, section 36, my lord, deals with, my lord, enforcement of an award. 36(1),
Yes.
my lord, it deals with enforcement of an award. 36(1), my lord, where the time for making an application to set aside an arbitrary award has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Civil Procedure Code in the same manner.
Correct.
So, my lord, 36, my lord, by itself, my lord, only says that, my lord, first of all, my lord, 36(1) says, my lord, at what juncture, my lord, it will be enforced. That, my lord, is twofold in nature. When, my lord, the time to make 34 has expired.
Yes.
Previously, my lord, it was 34 has expired, and, my lord, the execution proceedings, my lord, are pending. then, my lord, it will be enforced in accordance with the provisions of the Civil Procedure Code.
Yes.
Then, my lord, subsection 2 says, where an application to set aside the arbitral award has been filed in court under section 34,
Yes.
the filing of such an application shall not by itself render the award unenforceable unless the court grants a stay of the operation of the said arbitral award in accordance with the provisions of subsection 3 on a separate application to be made for that purpose. So, my lord, really speaking, my lord, the award is being stayed. And that is, my lord, being stayed. Really speaking, that is an order, my lord, under section 34 and not under section 36. Because 36, my lord, deals only with the procedure. It only says, my lord, at what juncture it will be enforced. And it says, my lord, that, my lord, it will be in terms of, my lord, the Civil Procedure Code.
Very interesting point. Let us examine this point.
Yes.
The
Lord,
first regular
Just
first appeal
expand
is
it a
filed.
little more before your lordship.
Very interesting.
Yes, my
that really
Yes.
that I lose my
No, my lord, go ahead.
patience.
My lord, your lordship will do that.
Suppose the
I'll take notes.
first appeal is filed against a money decree before a district court judge. Take a very hypothetical example. Suit was filed before the civil judge junior division and suit was decreed against that. First appeal is filed before the district judge. The district judge passes an order of stay. Now that order is to be challenged further. If the order is passed on a decree, then section 96 contemplates appealable order. Then in that event, the order of stay which is passed is further appealable before the High Court. Has to be, because it will be deemed to have been passed on a decree, and section 96 says appeal lies against every decree. So in that event, the further appeal would lie to the High Court against that order.
Yes. My lord, let me, my lord,
No.
my lord, let me, my lord, go strictly, my
no.
lord, by, my lord, let me go strictly by, my lord, the provisions of section 36.
This is an additional right.
My lord,
Suppose
assuming, my
like
lord,
order 41 rule 5, which
let-
says that the appellate court can stay.
my lord, let me, my lord, take
Anyway.
take it a little further. My lord, supposing, my lord, no section 36 has yet been filed.
True.
I have filed, my lord, under 34.
Challenging. No
I-
difficulty.
I apply for stay. Stay is granted.
Correct.
It's an order under 34 or
The 34 contemplates stay.
so, my
First
lord,
thing is the court derives jurisdiction from powers conferred under the statute.
yes.
There are two modes. I must be very candid because
No, my lord, please.
let us have a learning process.
Yes, my lord.
There is no contemplation. Suppose section 36 was not there when initially
It was there, but it was in a
But it
changed
was
form. 36(2) was not there.
no. 36 means in this form was not there.
Yes,
Question of stay was not there.
automatic stay.
It was an automatic stay. Let us contemplate a situation that there is no concept of automatic stay. Let us see. But there is no power where conferred upon the court to grant a stay. Then the first and foremost question is that if the proceeding is filed before the court, then the procedural law which regulates such proceeding would be applicable to that proceeding as well. One can invoke an inherent power in granting the stay. I'm drawing an analogy from a old judgment of the Supreme Court, probably AIR 1964 Supreme Court, where in relation to an income tax matter, there the power was conferred upon the appellate authority to vary and set aside the assessment order. The power to pass the order of stay pending that final consideration was not reserved. Then the apex court held that when the authority has been vested with the power to set aside the order, to quash,
Then
modify,
automatically
whatever.
to stay also.
So power to grant stay is inbuilt, inherent in his jurisdiction.
Lordship.
Now here, the court will apply the inherent powers which has
Lord, I
there.
appreciate. I take a
That
cue
being
from
the
your
position.
lordship. I take a cue from your lordship.
That's true. And that being the position,
So, my lord, I
then
take,
the power which is applied inherently will be considered to have been applied in a procedural law applicable to that proceedings or applicable to that
my lord,
court.
I take a cue from your lordship. My lord. I
It
bow
will
down
be-
to you.
It will be a like a order.
I bow
that
down to your lord.
sense.
My lord, let me formulate. My lord, there are two propositions which I want to place for your lordship's consideration and then leave it to your lordship. My lord, the first is that, my lord, there can be a stay of operation of an award at a stage even prior to the institution of 36. There can be no 36 prior to 34, but there can be 34 prior to 36. If there can be 34 prior to 36, then an order can be passed taking a cue from your lordship. If there is a power to set aside the award, then the court must be deemed to have the inherent power to stay the award.
But now,
If that is,
correct, but source of power. The source of power does not emanate from 34.
it emanates, my lord, from 36. My lord, let me, my lord, make
Does
my
not.
submission.
Then it will emanate either under Order 41, Rule 5. If it is not, it will emanate under Section
I'm coming
151.
there. I'm coming there.
151. In both the situations, the appeal does not lie.
My lord, I'm coming. My lord, your lordship will have to bear with me for a little while, my lord, because I'm trying
But
to.
nowadays, I have become too patient. Don't worry. I am not.
No, my lord, it's welcome, my
Talking
lord,
much.
because my lord, I think that is the true purpose, my lord. Although we are now caught in the, my lord, race of disposal of matters and how many matters are done per day. But my lord, if I think especially for the appeal court, that's what the appeal court is there for. My lord, be that as it may, my lord, I am arguing a twofold proposition. The first proposition is, my lord, like I have already tried to summarize, that, my lord, we cannot say outright that the power to pass an order of stay does not exist in the Section 34 court. Usually Section 34 court and Section 36 court is the same court, but for the purpose of the statute, let us, my lord, consider them to be different. So, my lord, if there is a power vested in the Section 34 court to set aside the award, then, my lord, it has to be presumed that Section 34 court has the inbuilt inherent power also to stay the award. If it has the power to stay the award, then 34, my lord, is appealable under 37, which is appealable under, my lord, Section 13, my lord, of the Commercial Court Act. That's, my lord, one line of argument. Second line of argument, my lord, is, my lord, Section 13 of the Commercial Courts Act has no application whatsoever. Once, my lord, a matter, even, my lord, if the matter was in the commercial division, once it comes up for execution, the Commercial Courts Act, my lord, stops applying to it. My lord, kindly take Section 13 of the Commercial Courts Act once.
Yes, I have.
My lord, kindly see, my lord, first of all, my lord, in these 16 sections, my lord, which comprise, my lord, the whole of this act, you will find, my lord, not a single section devoted to execution. Nothing at all devoted to execution. So, my lord, my respectful submission is that, my lord, the Commercial Courts Act applies only till the stage of the passing of the decree and not thereafter. There is no provision in the Commercial Courts Act, my lord, which relates to execution of decrees. Now kindly take Section 13. And if it does not relate, my lord, if there is no provision in the Commercial Courts Act subsequent to the decretal stage, then, my lord, an order passed in execution proceedings, my lord, will not, my lord, be appealable under section 13 of the Commercial Courts Act. And hence Commercial Courts Act or section 13 thereof, my lord, will have no application. Now, my lord, kindly have section 13 once and kindly permit me to point out, my lord, the heading first. My lord, the heading says appeals from decrees of commercial courts and commercial divisions. Any person aggrieved by a judgment and order of the commercial court so and so may appeal the commercial appellate court within 60 days from the date of judgment and order. Any person so and so. Now, my lord, kindly see, my lord, it deals only with order 43 and section 37. It doesn't deal with order 41. Doesn't deal with appeal from decrees at all. Appeal from decrees, my lord, therefore, are excluded from the purview introduced by the proviso. And my lord, the proviso, my lord, has to be given precedence above, my lord, the general section, because the proviso carves out the exception. Now, my lord, therefore, your lordships, my lord, will read, my lord, the proviso as having an overriding effect on section 13 itself. And, my lord, the proviso restricts it only, my lord, to the pre-decretal stage, which is order 43. And the Arbitration Act, my lord, of course, does not deal with decrees. It deals with awards. There is a separate treatment of that. So today, my lord, now if your lordship takes, my lord, 36(2) of the Arbitration Act and 36(1), starting with 36(1).
Yes.
My lord, 36(1) makes it clear, my lord, that the enforcement will be in accordance with the CPC. The enforcement, my lord, will be in accordance with the CPC. And thereafter, my lord, 36(2) says, again, it reiterates, unless the court grants an order of stay of operation of the said arbitral award in accordance with the provisions of subsection 3 on a separate application to be made for that purpose. Upon the filing of an application under subsection 2 for stay of operation of the arbitral award, court may, subject to such conditions as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing, provided that the court shall, while considering the application for grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of money decree under the provisions of the Code of Civil Procedure Code. So, my lord, brings in, my lord, order 41. And, my lord, if order 41 is appealable, my lord, under 36, then, my lord, it becomes appealable, my lord, under section 13.
Order 41 becomes appellable?
No, my lord, your lordship sees, my lord, provided that the court shall, while considering the application for grant of stay
Yes.
in the case of an arbitral award for payment of money,
Correct.
have due regard to the provisions for grant of stay of a money decree.
Correct.
So, my lord, we are now talking about, my lord, order 41, rule 5.
True.
Under the provisions of the Code of Civil Procedure.
True.
So, my lord, therefore, my lord, under section 36, applications for stay of the award will in effect be tried under order 41, rule 5.
True. True.
Now, my lord, if it is to be tried under order 41, rule 5,
True.
now, my lord, read it with the heading of, my lord, section 13.
True.
And perhaps this is, my lord, what it wants to say.
Yes.
Appeals from decrees, then it will be treated as an appeal from a decree, which would, my lord, be appealable under section 30.
Then why the proviso was interested?
My lord, there are two ways, respectfully, my lord, of looking at it. My lord, one is, my lord, if your lordship looks just at the proviso, then, my lord, the entire execution provision is excluded from the purview of the act.
I could not gather it. What you really wanted to say? I could not.
My lord, since, my lord, order 43 is dealing with appeals from orders
Correct.
and not appeals from decrees.
No.
So, my lord, appeals from decrees, my lord, if your lordship treats an award, my lord, to be a decree in that sense,
Has the trapping of a decree.
has the trappings of a decree.
Correct.
So, my lord, that would also be excluded.
No, why it will be excluded? Because the proviso is restricted to an order. It does not talk about the
Correct.
judgment.
So it is, proviso is
Talk about
restricted.
the judgment. Subsection 1 talks
Yes,
about both the
order
judgment and
41.
order.
It deals with my lord, first of all, my lord, your lordship is talking about execution and stay in execution. My lord, execution and stay in execution is not provided under the Commercial Court Act.
True,
Number one.
true.
Number two is, therefore, my lord, in matters which, my lord, come up, which are, my lord, post decree or post award,
Yes.
which is akin to a decree. The question arises, how will your lordships treat it then?
Yes.
There, my lord, your lordships can perhaps take a cue from 36(3), which says, my lord, that these will be, my lord, treated really as being, my lord, under order 41, rule 5. Because, my lord, it will be treated as a money award. In my case, it is a money award.
It's a principle akin to this order 41 because the section 34 does not really is not acting as an appellate court. Section 34 court is not in essence or technically is an appellate court.
Well, it sits in
So-
appeal over the arbitrator.
Or whatever, but that is what it says that on these grounds, and that's why the word which is
But, my
used
lord,
is an application.
no, my lord, may I just put
Section
it this way?
34, if I am not wrong,
Lord-
application, it talks about the application. It does not talk about the memorandum.
No, my lord, I am not on the memorandum or the application. My lord, kindly see the essence. Kindly see the essence. It is saying that, my lord, if you want to execute or you want to stay an award, you will have to do it under the provisions of order 41. Now, my lord, this is not appealable under section 13. Order 41 is not appealable under section 13.
What it says is order 36. This says that decree
Section
under the
36.
provisions of the codicil procedure means for grant of a stay of a money degree under the provisions of the codicil procedure. So by that necessary reference, certain provisions have been brought. That means the principles of those have been brought by virtue of this.
Yes, yes.
It's nothing that it cannot say that actually that provision applies.
My lord, it says, what it does say, the exact wording is
Exact, I have seen that. That have due regard.
regard to the provisions for grant
provisions
of stay.
For grant of the stay under the provision. Due regard
Yes,
means the principles.
very well, very well,
Principles.
very well. The principles of order 41, rule 5.
True.
Now, my lord, therefore, my lord, if I go back, my lord, to my original argument, my lord, it just says section 36, therefore, my lord, is not the equivalent of, my lord, order 21 of the code. It just specifies section 36 is not the equivalent of order 21 of the code. It just specifies that it will be executed following the procedure, my lord, of the Civil Procedure Code, following the provisions of the Civil Procedure Code. Therefore, my lord, when your lordship stay, my lord, an award or a decree or anything, then, my lord, the question that, my lord, arises is, my lord, do your lordship stay an award under 36 or under 34? My lord, the 36 has no power as such, my lord, for, my lord, execution or stay of execution. It is just saying the stage at which, my lord, an award will be executed And my lord, it just says do it in reference to the CPC, do it in reference to Order 41, Rule 5. It doesn't, my lord, say anything else. So either, my lord, the execution is under Order 21 of the CPC, or alternatively, my lord, it is under, my lord, Section 34 of the Arbitration Act. Because, my lord, we cannot, my lord, say that the court is denuded of power under Section 34. My lord, the stay always has to be of the award. And, my lord, it is the award which is under consideration and under challenge in a Section 34 proceeding, not in a Section 36 proceeding. 36, my lord, deals with nothing. Because, my lord, the execution is under Order 21, under the CPC. My lord, we, my lord, perhaps, my lord, erroneously refer to execution of an award under Section 36. No, execution of an award, my lord, is under CPC. And Commercial Courts Act, my lord, comes to an end, my lord, once, my lord, an award is passed.
Yes.
Now, my lord, the question that, my lord, thereafter, my lord, begs your lordship's kind consideration.
Yes.
Is, my lord, then, my lord, what meaning do we give to the heading, my lord, of Section 13 of the Commercial Courts Act? Because it says appeals from decrees. And then by the proviso, my lord, it excludes decrees. So, my lord, therefore, if, my lord, some meaning at all is to be given to, my lord, the heading of the section,
Yes.
my lord, kindly see 1A, any person aggrieved by the judgment and order of the commercial court, the level of the district judge so-and-so as the case may be, commercial division may appeal to the commercial appellate division of the High Court within 30 days. So, my lord, your lordship sees that aggrieved by a judgment and order of the commercial court. So, my lord, the inclusion of the word judgment my lord, would be in conformity respectfully, my lord, with the heading, which talks about, my lord, appeals from decrees. Otherwise, my lord, we will not be able to give any meaning to, my lord, the heading and, my lord, the use of the word judgment.
Yes.
And thereafter, my lord, it would mean that, my lord, any decree passed by the commercial court would be, my lord, not appealable at all. So, my lord, a final decree passed by the commercial court would also become non-appealable if, my lord, we are to go strictly by the proviso. Therefore, my lord, since the proviso does not carve out, so, my lord, all appeals, my lord, from decrees of the commercial court would then, my lord, lie straight away before the Supreme Court. There is no other, my lord, no other, my lord, even, my lord, passed by the commercial divisions, my lord, of the district courts would lie straight, my lord, before the Honorable Supreme Court. So, my lord, if we are to my lord, give a proper interpretation to this proviso, then, my lord, orders passed, my lord, after the decree, and those category of orders not being specified and not being restricted, my lord, either to order 41 or to order 43, my lord, would respectfully, my lord, have to include the entire gamut of orders, which, my lord, would be appealable in an intra-court appeal, or under the appellate provisions, my lord, of the court. Because, my lord, otherwise, kindly see, my lord, the completely unworkable situation which arises. Otherwise, my lord, today, my lord, in this particular matter, your lordship is dealing with an award. Supposing, my lord, your lordship was dealing with my lord, an execution of a decree passed by the commercial division of a court. Then, my lord, no appeal from that would be possible. And, my lord, the decree itself would be would not be appealable. So, my lord, this restrictive covenant in the proviso, my lord, would really tantamount to, my lord, making the commercial division the final arbiter of, my lord, all disputes, my lord, arising, my lord, within the meaning of section 2, which are commercial disputes. There's no scope of interference by the appeal court, except for, my lord, this heading, appeals from decrees. So, my lord, if your lordships can, my lord, entertain appeals from, my lord, final decrees passed, my lord, by the commercial division, then, my lord, by exercise of the same power, your lordship would, my lord, respectfully be, my lord, entitled, or would have the jurisdiction to, my lord, entertain, my lord, appeals, my lord, passed, my lord, in, my lord, execution of awards pertaining particularly to stay. My lord, right now, my lord, I am not talking about the general gamut, my lord, of this thing. Because, my lord, section 36 is not appealable under 37. But, my lord, an order of stay can never be passed under 36. There is no provision in 36 in that regard. Not a single provision in 36, my lord, which is akin to order 21. Where is the power under 36, my lord, to pass stay? Where is the power, my lord, to, my lord, or pass any other order? So, my lord, 36 respectfully, my lord, is a referral provision. You are now ready. The award is ready for enforcement. Go under the CPC. That is what it means. And the only additional thing it says is that if you want to execute the award, then you have to obtain a proper stay. And that stay, my lord, respectfully, can only be passed under 34, because 34 is the court dealing with the award. So whether the award will be set aside, my lord, and I am grateful, my lord, I take this cue, my lord, which has fallen from your lordships. If, my lord, the power to set aside the award is vested in the 34 court, then, my lord, the power to stay the award must also be vested in the 34 court. It may have, the order may have been passed in a proceeding under section 37, but 36 is not, my lord, the provision. It is in an execution proceeding filed under 36. But 36, my lord, is not the power to stay. The power to stay is, my lord, vested in 34, which is, my lord, appealable in 37. আর কি বলবো? হ্যাঁ, ইন্টারপোর্ট অফিসার ওর এইটাও ওর এপিএল order 43 is not applying to. মানে এটা বলার দরকার নেই। Only one further submission, my lord, very small submission. My lord, in view of this, my lord, your lordship will kindly see, my lord, whether, my lord, section 13 has to be given, my lord, a restrictive meaning or, my lord, an expansive meaning. My lord, therefore, my lord, your lordship will see, my lord, if, my lord, appeals are being entertained from final decrees, but, my lord, they are, my lord, within the exception of the proviso. My lord, kindly also take, my lord, section 14, expeditious disposal of appeals. I mean, it doesn't say about decrees. My lord, lordship will leave that alone. So, my lord, your lordship will see, my lord, whether, my lord, having regard to, my lord, our system of hierarchy of courts, my lord, whether this is the intention of the legislature, that, my lord, because, my lord, there is, my lord, no provision relating to execution. So, my lord, how does one come, my lord? So, execution, my lord, it ends over there. So, no appeal from any execution, any order in execution.
Yes.
So, my lord, these are, my lord, now, my lord, kindly consider this in the light of the judgment cited by Mr. Bose. I, my lord, do not think, my lord, that these, my lord, aspects of the matter, my lord, were considered. My lord, this judgment, my lord, if we come to the reasoning portion, my lord, at page 5, page numbers are at the bottom. My lord, page 5 towards the middle. Now let me consider section 13 of the Commercial Courts Act. An appeal would lie from a judgment and order. Orders from which such appeals lie are limited to order 43 CPC, read with section 104 thereof, and section 37. The proviso makes it absolutely clear that apart from the appealable decrees and orders, appeals do not lie from any other decision, notwithstanding anything contained in any other law, including the letters patent. An order under 36(2) and 3 of the Arbitration Conciliation Act is not one of the orders contemplated, so and so. So, my lord, this is, my lord, very simply, my lord, put. 36(2) is not appealable under 37, and therefore you are out. So, my lord, I don't think, my lord, these other aspects of the matter, my lord, have really been considered. My lord, I am not, my lord, this particular judgment does not apply to my case, because it is not my case, my lord, that 36(2) is appealable. Because I am contending, my lord, that, my lord, the stay of operation of the award is not under 36(2). It is, my lord, under section 34. My lord, these are my respective submissions.
Thank you. For orders on Monday. Both the councils completed further arguments. Let this matter be listed on Monday for orders.
May I?
What?
No, just a few provision. My submission would be that in rejoinder that what Mr. Shah has submitted is contrary to the amended provisions of the Arbitration Act and the Commercial Courts Act. 36 has been amended in 2015, and my lord, your lordship will see section 13 of the Commercial Courts Act whose amendment in 2018. So both are contrary to both the amendments. Amendment makes it abundantly clear, and they have all been taken into consideration. And my lord, apart from that, my lord,
I have read the amended act only. I have not read the previous act.
so these submissions are contrary to that. And my lord, there are not one, there are several judgments which says that 37 appeals are only against setting aside or refusing to set aside an arbitral award, nothing more than that. If your lordship will say take 37, specifically clear setting aside or refusing to set aside an arbitral award under section 34. C, 37, 1C.
Yes.
Only that. So, my lord, his application before the trial court was under section 36, that is page 45 of the stay petition. And he prays. Now, if your lordship will kindly take 136. Subsection 2 says that if you want stay, the choice is with the party who has suffered the award. If you want stay, then you have to file a separate application. My lord, this is contemplated under subsection 2. Kindly, your lordship, see. Separate application for that purpose. And that separate application is considered on the principles of the civil procedure code. Court may stay, may not stay. And for the purpose of staying, order 41 rule 3 needs to be considered. Civil procedure code. So the order which has been passed in exercise of powers under subsection 3 of section 36 does not fall under any of the provisions or subclauses of 37, which is the only appealable order provisions under the Arbitration Act.
Yes.
And my lord, if we now go back to the Commercial Courts Act, my lord, if your lordship will see, the Commercial Court Act is absolutely clear. 13. Appeals from decrees of commercial courts and commercial divisions. If you 1A, after the amendment of 2018, 1A was added. The entirety was changed. In fact, your lordship sees 1A. Any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising ordinary, original, or as the case may be, commercial division of the High Court may appeal to the commercial appellate division or the High Court within period of service. So this is the provision for appeal for any order. And proviso is the, if it is from a normal civil appeal, order 43 orders will be appealable. Otherwise, 37 orders will be appealable.
37. Arbitration.
So the scope of the appeal is either 37 appeal if it is from the Arbitration Act, or order 43 appeals if it's from a regular civil appeal.
Sir, only one thing apropos what Mr. Bose has said, my lord. Since
Reply
we are
to
trying
reply.
to, since we are trying to, my lord, understand.
Reply
the-
to reply.
No, my lord, since we are trying to, my lord, interpret a section, only then. Otherwise, no, my lord.
In fact, I have come across, I mean, in course, I've come across several judgments now where Supreme Court is saying, my lord, I have them in M. Hakim, Supreme Court has said, court has no power under 34 except to set aside or to affirm the award. Partial setting aside, nothing, not permissible.
Remand,
May not be, may not be.
remand.
No, remand is also limited to 34 subsection 4. Only limited to that. And in fact, my lord, that is there in section 34 also, one of the provision on only on limited ground.
My lord, may I, my lord, try to give a justification to what, the only one thing which I thought, my lord, needs a reply. He says, my lord, that appealable under 37, 34 is appealable, but comes with a qualification. What is the qualification? Granting or refusing, no, sorry. The qualification is
C, 34.
setting aside or refusing to set aside. Therefore, my lord, an order of stay, my lord, is under what provision if we ask ourselves this question? It would, my lord, also, if it is, my lord, being exercised in a section 34 proceeding, where, my lord, the court has ultimately the power to set aside the award. In the interim, my lord, it's exercising powers then under what? My lord, kindly now consider section 9. Section 9 is the power of the court to pass an interim order before, during, or after the arbitral award. So it would be, my lord, an order under section 9, which is appealable under 37. These are my respective solutions. Because, my lord, if the power exists under 34, and if you say that 34 is concerned only with allowing or refuse or
Post award situation is qualified before the award is put into execution.
My lord,
Our
Section
judgment
9,
is
Section
affirmed
9,
by the Supreme Court.
there restriction pre, during, no problem, post restriction.
yes.
Still enforced.
Now, my lord, your lordship will kindly see this, my lord. So, my lord, your lordship will kindly see this stay that
Anyhow, that power is there, Section 9.
very
You're
well,
taking an alternative argument.
lordship.
Mr. Saha always wanted to have a last word.
Always. We are used to
No,
it.
but
Very
this
strict.
particular point he raised, my lord, I thought it, my lord, required a
No,
reply.
It's on a lighter side.
No, no, I am not saying, I am
Yeah.
not, I am conscious of that, my lord. Grateful, my lord. My lord, your lordship does not want us to, my lord, summarize this in a one-page.
You have already done it. I have seen.
Very.
I have seen that.
For the respondent decree holder. We have concluded our submissions, Lord. Then, Lord, the appellant has also concluded. Then, Lord, they took out an application under Order 41, Rule 27, on which, Lord, I have concluded my submissions, Lord. He has to just give a reply. Thereafter, Lord, the benches change, Lord. Lordship.
Now the difficulty is because the bench has changed.
Yes. That
Lord-
is why the time taken. Otherwise, this was concluded.
Now he'll have to do it a de novo because my brother was not there.
No, it's for the appellant to do that, not because I tell you, Lordship, why.
The difficulty is because my brother was not there. At that point of time, now he has a right to.
No, my lord.
So,
Lordship will fix a date. Because I tell you, Lordship, decretal dues, Lord, which they have deposited, Lord, is over now 2.5
better to
crore.
go to the
2.5
regular
crore.
court. It's better to go to the regular court.
I entirely, in regular court, I will tell you, Lordship, the entire exercise that was done, Lord, would be
So
set
because
up.
of this, the bench broke. That is the problem.
Problem, I understand, Lord. Problem for justice.
Because that is not possible before this side of the vacation.
No. See, any date after the vacation, Lord. Any date after the vacation, I will not take more than half an hour. No
This is
evidence.
relating to 34 appeal. I mean
No.
37.
No. This is a decree in a regular suit.
Oh, in a regular suit.
Yes.
Now there is already a regular court of appeal.
I can't force your lordship that, but
It's
not the
better.
entire exercise will come to a knot, Lord, for after all these days.
But the problem is, so far as me personally is concerned, no problem. But my brother has to hear out. You have
Lordship
to
will-
argue from the scratch.
Lordship will brief your lordship's brother. That is good
Ah.
enough.
I cannot influence the mind in this way. I may have a particular notion, but he has to take
No,
an independent call.
factually, not on the conclusion part. Factually, your lordship can brief my lord.
The selected facts. Mr. Chatterjee, you are veteran in the profession, seasoned person, you know. Selected facts will be percolated.
I'll entirely leave it to the court.
It's better to go to bed.
No, this was specially assigned to your lordship.
This bench does not intend to take up this matter. on the
It is a
personal
specially
reasons.
assigned matter, Lord.
That's why we have to release it. This bench does not intend to, do not intend to take up this matter. For personal reasons. Let this matter be released from this bench and be placed before the Honorable Chief Justice for appropriate order.
Not to apply before the regular bench, Lord.
Oh, assignment is cancelled now. You'll
Or
have
then
to move before
court
this.
number 1. Grateful.
I'm grateful, Madam.
I had concluded Lux. So Chawat was not there for 2 days. So
Lordship, I'm appearing for the respondents. There has been a little bit dispute with
they were
the.
not there, Milord. I am there, Milord. Lordship gave me the outer limits. I said half an hour, Lordship said 15 minutes for my reply.
I-
They were not there thrice, Milord. I am, Milord, always responding.
Yes, I understand your lordship, but there has been a dispute with the advocate on records. Now there has been a change in the advocate on records. The erstwhile advocate
I
on
have never
record
prayed for time.
has-
Whereas, Milord, once
the
I was
erstwhile
invited for one-
advocate on record is not delivering all the documents to the current advocate on record. So I'm just asking for your lordship 1 week's time to get all the papers and then a
We are
date to be
granting
fixed.
you more liberty in this regard.
Yes, your lordship, the liberties have been extremely like more than anybody
More
deserves.
liberty in this regard.
That is true, your lordship, but just last,
Releasing the matter so that you can go and argue the matters.
kindly don't do that, your lordship, because the advocates have been changed just now.
Whatever, because we have been hearing this matter for a pretty long time. And ultimately, this is the,
I am there.
may I
Lordship,
use the
remember.
fulcrum of the entire.
I understand, your lordship.
I
This
will
is
not
the,
sit here from the morning. Thrice has happened. Milord.
but your lordship,
Otherwise,
a litigant cannot be made to suffer for
fact,
the
lordship,
the
Milord,
disputes
told
of
me
the
to-
advocate on records. I understand the situation is extremely troublesome for your lordships.
It was heard for a pretty long time by both of us.
All I'm asking, your lordship, one more chance, and I'm giving the undertaking that it will come and appear and finish the arguments on the next week. This is not forgivable. I understand your lordships.
Because by this time, because of the time
everything
lag,
has been washed. away.
everything,
It's now a clean slate.
because they completed, we know. Thereafter, you were taking time, sometimes there, this problem, that problem.
That thrice they took Milord. In fact, Lordship told me to ask Mr. Bachawat, since he's my chamber senior on the other side.
Even one day, we requested that go and contact Mr. Bachawa.
Yes, I also did that, Milord. Lordship gave me only 15 minutes time, Milord, to complete it. Lord, that was in my response. That's all.
I understand the liberties, your lordship. I bow down before your lordship with only one request, one more chance, your lordship. If it
We are
doesn't happen,
releasing the matter. You go and argue afresh. You have to argue. Because I think the last time we heard you was when
June, Milord. Perhaps June.
just imagine.
but your lordship, the advocates have been changed just now. Only one more chance, one last chance, your lordship, will appear and finish the arguments. Just one last
The
chance.
difficulty is that we do not have any, the original site regular determination.
Correct.
And the difficulty is that we'll have to sit for those matters
And 100,
and look when those matters are not ready. So
The-
it's better we will release all those matters and then regular bench is already there. Let the regular bench take up those
one more
matters.
chance, your lordship. Just
the
one more
difference.
chance. I
We
understand.
have
Your,
to sit only for these matters.
I understand your lordship is going through a lot of trouble because of the conduct of the respondents out here.
No, this is
But
not-
one more consideration, and after that, your lordship can take the call. Just one more, your lordship. There is no other options.
And we do not know because that another
It has to be argued again, Milord.
after vacation, we don't know.
No, your lordship, there doesn't have to be
For
after
the regular
vacation.
bench.
Before vacation, because I know this will take time. Before vacation, hardly some days are left. There are many urgent matters. Those are appearing in the list. to be
Lordship,
taken
let
up.
us go back to the
Use
regular bench, Milord,
this
because it has to be re-argued.
better.
There is nothing remains, Milord. Lordship,
Yes.
very difficult to remember, keep track. Milord, this
No,
takes
no, it's
us-
Lordship,
very
we
difficult.
will take the responsibility to make notes and make sure he
No,
he
it's very-
remembers every
How can-
fact.
how can-
But your lordship,
Let it go
next
to the
Let us go to the regular bench, Milord. Let us go.
Yes, same order. Release. Release. आगे order दीजिए ना this bench.
Great.
Do not incline to take up this matter. The person can be placed before the order of chief justice of passing.
Great.
great for your lordship.
Next three.
Please, Your Lordships, this is the appeal from the Calcutta Club suspension matter. In the Calcutta Club suspension matter,
We are releasing this.
Millard, this matter has been,
We are releasing this.
Your Lordship had been pleased to admit this appeal.
I understand, but anyhow, release. Next. For review of our judgment, let us see. Order. None appears in support of the application. In support of the review application. Sorry, in support of the review, the same is dismissed. What you want. Dismissed.
My lord, I am for the respondent. I am for the respondent number one, my lord.
No, he's appearing in person.
I am for the respondent.
You are appearing.
The corporation is supposed to file the report by the commissioner. Only, my lord, the compliance is left, my lord. Only, my lord, the compliance in respect of your lordship's order has not been done, my lord. I has not obtained anything, my lord. I have submitted the final decree along with the proposed plan for making construction before the corporation. The corporation, my lord, by its later dated, Lord, I suppose 24th August 2023 asks me for tax receipt with no due clearance, structural stability certificate, registered boundary declaration as there is no proper demarcation or physical boundary. My lord, I mention one thing, it is pertinent to mention one thing. Pegging has already been done.
Oh, I know. I will take care because that when the final decree is passed, there is no difficulty.
Yes.
We understand that has to be done in this way.
Yes.
They cannot insist that you'll have to give. But so far as those no objections and all, everything is concerned.
I have forwarded a copy, my lord, annexing, my lord, all documents, my lord, including the final decree. I have only one copy with me.
No. Have you said that there is no dues on the tax?
Yes. Yes.
Have you
Yes.
given all this?
Yes, my lord.
But so far concerning our proposed lot B,
Yes.
there is no amenities that will lodge is
No,
already
that is what I wanted.
Yes,
I
no,
wanted
may I
that
submit-
those amenities has to be provided. Now, have you applied for those amenities?
because my plan is already there. My
What?
on 9 July 2011,
No, what?
the plan that was not sanctioned by the corporation for
That my lord,
issues.
four-story building
My
plan.
lord, what has
Four-story
happened?
building plan.
Please, my lord, may I submit this thing? What the corporation did on 25th August after the order.
Let me understand first.
Lord,
There is already a preliminary decree passed. Nobody has, I think that attained finality. If you have challenged, appeal and all, everything gone.
assisting to my
No, I'm just asking now, just trying to come to a point.
Lord,
I want to just come to a bullseye. So preliminary degree, no problem, attained finality. Final degree has already been passed. Challenge, I do not know, made or not made, unsuccessful. Final degree is also, the final degree attained final.
Yes.
Now at the execution stage when it comes, the final degree. Now nobody can go beyond the final decree which has already been passed. If that being the position, then we'll have to respect that what final degree says. If the final degree says that this lot A will go to you or go to them, lot B will go to them or go to you, we have to just see that what that lot B is. If it appears that in the lot B, there are certain facilities or amenities not provided, obviously you have a right. You can say that, so say for a the toilet facilities, for a staircase, for an access to the roof. I can understand that one can have a grievance in this regard, that I can't be in a captivity, I can't be there, that I cannot move anywhere else. For that reason, we wanted the corporation to come and that whether it is feasible. If staircase can be done, you can construct it, no problem. If the washrooms, toilets can be constructed, no problem. You get it done. Resolve it. You have accepted the final decree. Means you could not get away with the final decree. Now that final decree has to be respected in all sense. Tell us that how this problem can be solved out and resolved. Tell us.
My lord, the corporation on one Sunday gave a notice affixing it without serving a personal notice, affixing it. Thereafter, they visited the premises after about 4 weeks.
Sir, the difficulty I tell you,
Mal-
the problem which I perceived in my life was the moment you remember the past, you cannot take a
It has
decision.
happened after my lord's order. It has happened after my lord's order.
Now, only thing is, sir, what you want, I really want it. You want that there is no staircase.
No.
You want a staircase? There is any toilets?
No.
You want a toilet? Can you suggest a plan where you can make a
And we
toilet?
have already given in 2011.
Again, there is a problem which comes, which says that that was a construction of a 4-story building in total.
That has to be done because the original building already, it is also the case of the plaintiff. It has not a good structure. It's an old building of about.
I understand, sir. That is why when this allotment was made, now 4-story building.
That's why 2 years time was given. That was a decree. That was not a final decree. With contingencies to make construction with reciprocity. That they are not confessing before your lordship.
What show us the final decree?
That is terms of settlement. That is not a final decree, lordship.
So that is what I really wanted.
Yes, that's what I.
That is a final decree.
What has happened, my lord?
My
lord, lordship.
Then why order 23 rule 3 is introduced in the code of civil procedure?
My lord, I am not on that.
Entered into between the parties.
That is correct. That
is not a decree. I am really at loss.
This is a decree.
So,
it is a decree. What has happened? The decree was drawn up in 2014 of 2007.
Sir, it is immaterial when it is drawn up.
Because all of what they have done, the years of the defendant number 2, without having been recorded, registered their names in the suit, they went to the corporation.
Why?
Because
Sir,
that
you
has
wanted
been the difficulty.
Sir, the difficulty lies somewhere else. I understand. Sir, your allotment.
For 2 minutes.
Please.
For 2 minutes. Literally for 2 minutes.
Listen for 1 minute.
Lordship.
You have been allotted a particular portion.
My predecessor. Yes.
You are deriving right from your predecessor.
My lord,
Are you not deriving right from your predecessor?
in this case, perhaps not. It's
No,
directly
independent.
from our grandfather.
That is the predecessor.
That is correct, my lord.
So,
The predecessor, immediate our predecessor, has set down with a settlement.
no, sir, you did not challenge that. That my immediate predecessor means my father. That is my father.
Challenging the executing order that is pending.
I am again against the what section 47 file.
Section 47 because it
Have
was
you
committed upon
succeeded?
the court.
I am again. Have you succeeded in getting any order of stay?
No.
Have you succeeded in setting aside the decree?
We
No.
didn't.
Section 47 is still alive.
My lord, section 47
Is still alive.
it is still alive.
Alive 47.
Tomorrow. It is date fixed before the executing court, their execution case. It has been found by the trial court.
I am again
and
saying
questioning.
section 47 is alive or not alive?
Alive.
What is the number of
That
section
is
47?
GA 8 or 7, my lord, perhaps. GA 7 or 8. It has been filed in both the execution cases. My lord, that is a separate aspect.
No, it has a very main aspect. Don't segregate it.
No.
I do not want to go.
My lord,
Because
that is
if I
pending
remember,
because
the earlier
the
division bench
desire
has
of
said
the-
that this was
desire of
this
the-
was
Cesar
dismissed.
testator, that is our grandfather, has been flouted by our immediate predecessor.
Hmm.
That was questioned by the court. And tomorrow they are supposed to give the answer to the court. They didn't prefer appeal against that order. But Lord, be that as it may, what I
Sorry.
want today is this. There are two basic problems. The corporation is not withdrawing the apportionment. They confessed when they came for inspection after my lord's order in the premises. I said them, they did not make any inspection. Simply they said, what solution can be done? Then I said,
Absolutely best approach which can be
that is
done.
correct. There were no other members. Only me and the plaintiff himself. No other members were there. I don't know whether they have been notified or not.
We were very much there, madam. I am for the defendant.
No, my lord, no signature has been obtained of them. They were not there in the premises. What he is telling in open court? This is absolutely misleading statement they are making. Corporation only heard me, heard the plaintiff. Nobody else was there. Nobody. No inspection was made. I said to the corporation that kindly Mr. B.K. Dhar, the building engineer who came to the premises, I said it is the observation of the Honorable Division Bench that if you keep this premises apportioned, there cannot be any cause. Kindly withdraw it. Since 2009, they have kept the premises apportioned. So, my lord, how can I make the construction? That is the question of the court.
Sir,
My lord, the apportionment was done by virtue of an order passed by the division bench.
Please, you kindly show that order.
What
You are
is-
totally
what is,
making a mistake.
what is the meaning of apportionment?
My lord,
Apportionment of the tax liability.
Yes.
That is a different. I am asking when a partition suit attained finality on the basis of a compromise decree at the final degree stage.
Yes.
Then in that event, the lots which have been agreed has to be divided vertically
Yes.
so that both the plots, both the portions are segregated from each other.
Yes.
We wanted that. Now, there are certain facilities which are already there in one lot, which is absent in second lot. We will see that the corporation takes care of that and permit the other allottees to make the construction of a toilet. If there is a no staircase, obviously, if it is a more than one storage building, there must be a staircase. How they will provision has to be given. We just wanted that to end the solution, the problem.
May I submit, my lord, two things?
Now, the difficulty is because both of you are at the logger's head.
My lord, may I submit?
That is the whole problem.
not me, my lord.
And if I use the term, please pardon my impertinence, on a dragger's dawn.
Not me, my lord, at least.
My lord, may I
It
submit
is
two
the
things, my lord?
observation of this court repeatedly since 2009.
My lord,
Repeated.
kindly one sees, my lord,
It is
the
not
order
my-
or
Give me your report. What is? Let me see first see the corporation.
In a blank paper, only I signed.
Sorry,
the plaintiff signed.
please have patience. Let us see what the corporation has said.
Lordship.
Shall I go to the list? No, I do not, at least, I am not happy with this report. No, this is not we wanted. We wanted that the corporation would see that this particular, I would say the stalemate situation or the stubbornness which is there, how it can be relieved or released. Again, you are still trying to suggest that they remain at the loggerhead and continue with the litigations. That is not. First thing is, when a decree is passed and a decree is submitted to you, and if they have already done a pegging, if they wanted to make certain construction, they have to raise a vertical wall on the basis of that particular pegging. Now, difficulty is, I tell you, it cannot be done, because if the staircase falls within a particular portion, then how the other lot holder will go to his respective portions? If you say that you raise the wall, how can he go? How can he go? No, you say that you jointly submit the plan. How can it be?
Along with the location of the portion.
No, that is what not you have said. That you have not said. Sorry.
One is, I am the glad in the partnership, which is very awkward for you. And my position that in interest of this, that who are building corporation, they should not be part of a partition should before your lordship.
Yes.
And there are structures. Again, this matter. That everything.
The court has a suo motu power under order 1 rule 10(2) to impede any intervener.
When and where everybody of the corporation will come before the lordship and submit a report, no problem. But we are the parties in a partition suit.
No, you're not a party. You are an intervener.
We are party.
They wrongly made it. You are not a party to the partition suit. You are an intervener. You have been allowed to intervene in the proceeding because of this. Now the situation is, unless they construct this, they cannot raise. You can ask for an undertaking from both of them that in the event this staircase is complete and the toilets or something is complete, you will have to raise a wall demarcating two portions differently. You can do that.
That's what the plan has been given. That plan has been.
What more?
Exactly keeping in mind in 2011. Lordship kind. This should be done, we will done. My lord. We cannot actually go outside the entity of the act of the corporation. That is the highest authority.
We will remember this argument, and you know, we will remember this argument and thereafter.
That is possible, but right now, before the court of the on that point.
What? We will. No, we don't remember. I will remember this argument, what you say, and then we will pass certain orders that I do not know what impact it will have. Only thing is definitely you are a statutory authorities. If a decree is passed, partition has been effected. Now, only question of, you said that stability certificate is.
Undivided said that asking your lordship, my lord, kindly, sir, that decree, there also, certain question,
Has to be. That is what is the outcome of a partition decree. Some party who is there in a position shall be uprooted therefrom and will be placed in another position. Somebody who there has to be uprooted. This is what are the, I would say, very common thing in a partition. They have to be. Sir, it is not a building which is built today. Right? Now, many buildings do not have that particular mandatory space. Your building does not have. So we'll say, tell the corporation to go and take action against it. Chisel out. In those days, there was no law in that regard. That law got changed subsequently. So all these old buildings are still there. They do not want that the old building should be tumbled down or to demolish. They just wanted that now the shares have gone. We wanted to separate the share. Now the question, what?
Everything is 100% no issue in the
Apply
My
for.
lord, mutation has been done in my name.
Done.
Can I show, my lord?
Mutation is done
Have
also.
you
in
done?
our-
Everybody's name has come.
Yes,
Mutation is done.
yes.
And my lord.
Mutation is done.
My
I do
lord,
not know why.
Your name has come.
I have not applied for.
Why?
That's why I'm answering. Since last 10 years, I'm trying to answer before the court. That has not been recorded. Lordship, kindly hear me once.
We will
Let me-
record this time.
Lordship, now hear me. Lordship, kindly hear me 5 minutes for this mutation.
Correct.
What has happened in 2009, both of them, plaintiffs and heirs of defendant number 2, who are not on record, applied before the corporation for mutation and apportionment. We objected to. The assessor collector, not Mrs. Rakhi Ganguly, wherein objection was filed, she refused, and that is on record in GA number 1493 of 2009. That is on record. Now, therein, without hearing me, the corporation has apportioned the property. What has happened thereafter? The court, the Honorable Single Bench was pleased to direct you file your plan within 15 days. There I prayed that this is barred under 178 of the KMC Act. Because that was not heard out, I filed a review, that was rejected, I preferred appeal. In that appeal, APO 423 of 2010, on 2nd February 2011, the Honorable Division Bench was pleased to hold that the mutation that I have objected to deemed to have been withdrawn. So the court directed me, within 3 weeks, you apply for the plan. I have done it. I have approached the corporation to withdraw the apportionment and allow me to make the separation, because unless there is a separation and mutation, I cannot make construction. That is the law of the KMC.
So why you are objecting to
Lordship,
mutation?
can you hear me?
Why?
Why? Lordship, kindly hear me.
Let me. No, I'm asking.
Apportionment, there cannot be any construction order dated 8 June
I
2011.
am asking you why you raised an objection on
Because
the
they have
mutation.
apportioned the property. In apportionment, there cannot be any construction. That is not my observation. Honorable Division Bench, 8/6/2011, 20th June 2011.
I am asking you a very simple question. I am not talking about apportionment. I am oblivion of the situation that what apportionment means.
That's why I'm answering, my
No, I know. You did not have to. Your understanding may be wrong.
Lordship.
But under the Kolkata Municipal Corporation Act, the apportionment, what does it mean? I know.
Lordship.
Now the question is, I am asking you, why you objected for mutation?
I have not objected for mutation. I applied for separation.
Correct.
That was my
now
previous
now
done.
first they say that unless the mutation is done,
Yes.
they
Separation
cannot,
and mutation. Separation
sir,
and mutation.
I am again saying
Mutation, there are
you are using a conjointing
Lordship,
certain
kindly
things.
excuse me, my
Please
lord.
let me segregate it. First is the object of mutation.
This mutation.
Now question is mutation.
What kind of mutation? That is the.
Now question is that they have not recognized as of the day that the property has been partitioned. They have not as yet. They wanted that still the entire larger property stands in the name of a deceased persons. They say that now, being a successors, you should come on record.
Grateful to your lordship.
Correct.
Lordship.
Apply for your name.
That I am
apply.
That I
Now,
want to do. But they are keeping in the name.
Is
Lordship.
they will apply for mutation. You will process the application for mutation on the basis of the judgment, preliminary decree passed by the court, where the rights of each of the parties has been declared. And on that basis, you effect the mutation.
Lordship.
Effect now.
Mother SSC number to be restored. Lordship. Lordship.
After doing that, then there is a final decree. Final decree says that how these portions shall be segregated and which portion will go to them. You have to assign a separate number for that. Segregation, separate number. That lot A is now registered as /1 or 2 and lot B will there. And according to that particular final degree, in whose the allotment that has gone, you have to just make that recording in your record so that to make them liable for this tax, the corporation tax. Thirdly, please they will apply for that particular construction under that particular final decree. Consider this. Take an undertaking from them that the moment the staircase access or the toilets are complete, then this demarcation, you go and make it there. They said pegging has been done. From there, they have to raise a wall, at least 5 feet or a 6 feet wall, just to make a demarcation.
My lord, this will create a ingress
This is
egress
what?
problem. This will create a ingress egress problem.
Really?
Because my lord, the main entrance gate is single. Now Indian Middle Street gate, that is not absolutely accessible at the moment. Now, if the wall is raised, my lord, that's what the plaintiff tried to raise and in fact raised.
Now,
That was-
now
Yes,
go there and find out that particular whether a separate entrance or
Because-
a gate can be provided.
separate
that-
entrance. There are 3 separate entrances, my
Not
lord.
three, two. My lord,
In both the lots, there are.
Yes,
there are 3 lots. Lot C is having no gate. Entrance
there
gate.
is a separate entrance for
Now,
them.
lot proposed-
entrance, we don't have.
Sir,
That is-
if I say anything
that is the
incorrect, if I say anything incorrect,
We are
kindly
saying-
rectify
we are
me.
saying-
He's allotted which one?
Lot B, proposed lot B.
Lot B has the separate.
Yes,
He
We have a
yes.
separate entrance, man.
My lord, my lord, the
So
lot,
go
lordship,
make an inspection. If it has, lot B has a absolutely exclusive entrance, exit, no problem.
what about washroom?
Lot C is not bothered. He say that I will take care of that. Lot A also say I will take care of that. So far as the entrance part is concerned, they will take care of.
My lord,
Only staircase.
staircase, washroom, underground.
Apply
water
for mutation.
reservoir. Lordship,
Yes.
lordship, kindly,
Because
Lot-
you will do a very great job for that.
my lord, lordship, kindly
Lord,
consider today we are deciding still jointly.
My lord,
Now today, if the wall is raised and if we are.
Are you not understanding
Yes, my
that
lord,
is
I understood.
because no, you did not.
Lordship,
When you utter this word, that means you did not apply your mind. Your mind, I think the doors of your mind is completely closed.
my lord.
You have
lordship,
not
my lord,
understood
that
it.
is our residence. My address has been taken away by corporation, my address. Lordship, kindly consider what we face in the residence, my lord, with the other lot holders. We are every day facing problem. Water reservoir pump operation, ingress egress, the furnitures are destroyed, kitchens are destroyed, water, this tulu, that is the water reservoir has been destroyed. My lord, many things we are facing, I am facing, not anybody else. Now, because I am standing in the way, why I am standing in the way? Because of the court's order. There are several court's orders which till date I couldn't address to before any court that which previously was passed.
There are two aspects in this. Then you'll have to introspect and ponder upon.
My lord,
That,
this is
what
my-
is
this
your
our
what is your
residence.
sir? Everybody has a residence. It is
Because
not your
they are having
residence.
amenities.
Please,
They are
this is
having
not.
amenities.
Please, this is not your residence only. Their residence also.
Yes,
Their
because they are having amenities.
please, what I said. That's why I say
Then
that,
lordship kindly
that
pass
please
this will not
shutter
prevent
of
us
your mind
what-
should be open.
Lordship,
That should be open. What I said to the corporation.
my lord, that is correct. The court-
No, you have not understood. You have not understood. That's the problem with you. We said, I will rather that first clear up that mutation problem. Everybody, it will be recorded
The
in the
joint name.
joint name of everybody.
Yes.
Till date, they have not given a separate. After they record, they will give a separate number for each premises.
Yes.
And then also record the names of a person who have been allotted that particular portion. Thirdly, say that these persons will apply for a construction of a certain, say, staircase or something. The moment they will apply, they will see, they will try to sanction those because that is the thing. And if the sanction is done, then that person will be able to make a construction of the staircase and the toilets.
Other constructions.
Whatever.
Lordship.
And the moment that construction is complete, before that permission is given, they will take an undertaking that after construction is complete, you'll have to raise a wall. That means you had a staircase and the toilet, then you raise a wall.
Lordship.
Not before that.
Lordship.
And you
My lord,
started
my lord,
saying
that's
that
what I was
that
saying.
is what I say with a closed mind.
No, my lord.
When the lawyer himself is the litigant, that's the problem.
My lord, since beginning I was telling, my lord,
This is what you are telling. We are saying to the corporation,
Lordship, kindly record that plan is
Sorry, not already.
already lying with
You have to.
My lord, that is already lying with them.
You will not. They have to submit. They have to submit a fresh plan after you complete the exercise. Yes.
And Lordship, kindly
My
record
lord,
that the
my lord,
trial
may
court
I-
is pursuing this about fraud upon the court committed by our predecessor.
That is
the
not
order
before
dated
your,
25th
that is
August.
not,
before.
No, because that proceeding is fixed tomorrow.
it is
Because
not.
that will, this
Again,
order,
I'm saying, sir, once you invite this bench to record, then you cannot prevent this bench to record his finding.
Lordship,
And if findings are such which will create a problem to you.
Lordship. My lord, I'm not submitting, my lord. But another thing, my lord, the major problem, my lord.
No problem.
Lordship, kindly hear me. What has practically happened? That already set
My
it
lord,
to the civil engineer.
my lord,
Now,
may I-
Bajar,
may I-
this metro rail collapse has
Pursuant to
taken
the
place.
order,
Now, already our
please have a patience.
Lordship, this metro rail issue is there now.
Now we do not want that. Metro will take care of that.
My lord, that is our building is affected. In
Under
our
order, the corporation submits the report.
report may be circulated, my lord.
It is indicated therein that the parties have not applied for a mutation
My lord,
in respect of
in
a
respect,
larger premises, in respect of a larger premises. And therefore, the corporation is not in a position to accept that the premises has been partitioned.
Schedule A property.
By virtue of the final decree. Final decree. However, the parties are at variance with the aforesaid notion of the corporation. Full stop. According to them, they have already picked the respective
Lot A and Lot
lots,
C.
respective
No, my lord,
lots.
Lot C has not taken place.
Either you dictate the order or let us dictate the order.
Pegging has been done.
Sir,
Lot A and
we are recording the submission which he has done.
Oh,
Mr. Mitro, that's a problem I have I'm facing this. When a lawyer himself is a litigant, there's a big problem. Even we are recording the submission of the other side, there also the interference comes. How can you put your words into the mouth of the other side? This is what we learned from you at the bar, that when the judge is dictating the order, do not interfere. Yes, after order is passed, if you say that this is what incorrect statement facts, we will definitely consider. Respective lots showing the demarcation in terms of the final decree, and therefore the contention of the corporation in this regard is incorrect. Without venturing to go into the nitty-gritty of the respective submissions advanced before us, we find substance in the stand of the corporation that the municipal record still stands in the name of a deceased person, and unless the names of the heirs and the legal representatives, heirs are brought on record, brought in the record by way of a mutation, further progress cannot be made in this regard. Though the councils have said that after the final decree passed in a partition suit, the applications were made for recording the names in a separated and or segregated portion, which in fact has been done in some cases, in cases. However, it appears that the the names of the present heirs have not been recorded in its entirety. We therefore direct the corporation to mutate the names of the heirs and legal representative of those the heirs of the said deceased on an application being made within 2 weeks from date in respect of the larger premises, and shall thereafter separate the premises in terms of the final decree by by assigning a separate premises number for that in this regard, and the names of the respective allottees who would be primarily responsible for the payment of the municipal taxes applicable and or assessed for such separated lot. After the completion of the aforesaid exercise, the parties shall be free to the parties shall submit the respective plan for construction in terms of the said final decree within 4 weeks from the date of the communication through a notice by the corporation having completed the aforesaid exercise. And if such plan is submitted, the corporation shall see that informed and or reasoned decision is taken in respect thereof in the light of the final decree passed in the partition suits. After the completion of the constructions in terms of the plan so submitted is strictly in terms of the final decree, the parties shall separate the portions by raising a vertical wall in terms of the final decree. It goes without saying that before the corporation proceeded to grant permission or sanction, an undertaking shall be secured from all the owners of the respective respective lots, that they would separate their lot by raising a wall after completion of the construction as indicated in the respective plan. In case of let this matter be listed 1 week after the reopening of this court, when the parties would apprise the court on the progress having made in this regard. However, the liberty is granted to the parties or their respective counsels to mention the matter in the event any immediate attention is required. Attention of the court is required.
My lord, the vacation is intervened. Vacation is intervened.
So we said after vacation.
No, that is fixed after vacation. But the process has to be completed within
their vacation is very limited. Don't.
My lord, at least I will not be there. I will not be there.
What?
I will be out of station.
So
My lord,
I have said what I have said is I have said within 2 weeks they have to apply.
my lord,
That will be done, and then thereafter you make a segregation. You take a time, then you inform them. After they inform, they will submit a then plan in terms of their respective lots, strictly in terms of the decree. And the moment it has gone to you, you will have to scrutinize this, take an informed decision and the proper decision in this regard. And then we say that the construction that thereafter that.
My lord, may I,
That has not given. We have not given that.
my lord, may I submit
Only
one
thing
thing?
is that they will have to submit the plan within 4 weeks from the date when you inform them that you have completed the entire.
My lord, I have already
I have indicated that.
my lord, I have already submitted my plan and my lot is mutated in my name.
I have seen that. You have been assigned a separate number.
Yes, yes.
Separate number.
Not
Yes.
separate number, apportioned as.
I am asking you.
My
They
lord-
have not said that it has a separate number. as
My lord,
given.
kindly, please, my lord.
Is a different. I know that is the apportionment is according to their respective portions. They have been the entire tax has been divided.
My lord, it has been
That does
divided,
not
my
mean-
lord. I have paid my tax, my lord. Kindly see.
Separate number you do not give.
My lord,
It's the same number.
my lord, separate SSC number has already been
No,
given.
no, SSC number will be given. Oh,
For lot A, my lord. For my lot, a separate SSC number has
Not
already been
separate.
given.
This is apportioned as his number given, address is the
that
same.
I accept your contention. He is not aware of the corporation law.
My lord, the one difficulty is, at least we may
That does
face,
not
my
mean
lord.
separation.
My lord,
Anyhow,
one difficulty is, my lord. In the meantime, as we are deciding
it is a
jointly.
apportionment will continue. There will not be any disruption in the apportionment.
Yes.
Only thing is the mutation that has to be done.
My lord, mutation has been done in respect of my portion.
Not portion.
My lord, lot
Only
A, my lord.
Your name along with others.
No, my lord, kindly see this, my lord. Kindly see this.
Have you allotted a separate premises number?
My lord, kindly see this.
Nothing.
My lord,
Kindly see these ones, my lord.
this order will not
Kindly see these ones.
recite jointly as we are reciting today. Lordship, kindly indicate that will create a problem, my lord. Already I have got SMS voice recordings with me. What has happened in the home?
My lord,
Lordship, kindly indicate it. As we are reciting today jointly, it will not be interpreted by the other side. Because we are having no amenities. That has been done previously and that will create problem tomorrow after this order. Lordship, kindly record it, my lord. My lord, this is our residence, man. Lordship, kindly already our address has been taken away without any.
Mr. Mitro, can a court pass an order directing the parties to live jointly?
No, my
I'm
lord.
asking.
What the users, the common user, we have no.
If they have a fundamental right, how they will live their life.
My lord,
Can the court pass an order that you'll have to live jointly? You can't. live
this will
separate.
not interfere about their residence as on date.
Now, tell me, this is what is an argument is at once.
My lord, what that practical problem we are facing? That practical problem residing because we are having no amenities.
Have you seen it? Check it up.
My lord, it has been. My lord, kindly.
I tell you, we have dictated the order. We will not sign for now.
Yes.
You just say if the separate number has been given, separate premises number, then the others you'll have to give a mutation. So we are just keeping that order in abeyance.
My lord,
Yes, definitely. Give
my
it.
lord, let the matter appear, my lord, on Monday.
Let them first ascertain, mention the matter when they get the instruction and then give that copy to him.
Report to be circulated as filed by the corporation today, my lord.
We will circulate on the next week. Don't worry.
Grateful to you. Grateful to you.
I'm grateful, man.
You are appearing on behalf of the appellants.
But this is a very old matter. And why I'm saying this is because my instructions are your lordship had appeared for us.
Oh,
That it is that old. But I don't, we couldn't get any.
then no question. No question.
I have written instructions.
No, definitely. Why not?
We have not seen, my lord, but
What is I could not recollect the name.
We have been appointed in 18, my advocate on record, so we did not know about this.
I have been hearing the matter for a pretty long time, but never seen your lordship as an opponent in this matter. In many other matters, I have seen
Never
you-
opponent with you.
in any other matter, I have seen you as opponent.
I have just seen the letter, but
Just
it should not be Lily, it should be
No, it may be that.
with Urmipala.
लेटर देखिए एक बार.
निर्मला मुखर्जी
Before my time, I know.
दारुण मौके भाई मौके को इटली के दिए जाए बोले इटली के दिए
No, Mr.
I'm sorry.
Mr. Mitro. The letter is such. Though I do not recollect.
I also do not recollect.
Look at the letter.
Without you.
No, why should they get the letter? They can't get the letter. So it's it's written to the attorney.
One of us, my name, is not inclined to take up this matter on his personal ground. Now, on the ground of having appeared in the matter.
It is claimed
Have you-
that you have appeared.
No, they have said.
That is, it has been claimed you
They
have
have
appeared.
said that several conferences with the then solicitor who was there held with me. So it's better. Let this matter be released from this bench and be placed before the Honorable Chief Justice for passing an appropriate order. I didn't know.
No, no. How
They
can
have
you-
indicated 1998 affair. How do I recollect?
No, no. Well, many conferences that you might have. According later, you held many conferences.
That's several conferences.
Several
The word is
conferences.
used
So if-
with the then solicitors. So it's
And
better.
and appeared for also appeared.
No,
in-
appearance has not been given. That's why. I
Oh,
said-
only conferences. Only conference.
That's why I do not
That's why I have
remember.
not seen your lordship.
Foresight,
as an
my
opponent.
client had.
That's why I also do not remember. Appearance I remember.
No, your lordship remembers conferences also.
Hmm.
Many conferences, not one.
Several.
The matter is assigned to your lordship because
And the difficulty is the gentleman which is disclosed is no longer in this world.
Which is a advocate which is no longer like.
And-
Solicitor is no longer in this world. I cannot verify from him.
Not the senior, not the leader that is mentioned. Though it's the nickname is
Lordship, may I, under compelling
Please.
circumstances, my lord, item number 4 was dismissed by my lords, my lord. My lord, kindly, my lord, give me a chance, my lord.
What? Only review memorandum
My lord,
without any
my lord, my
application
lord,
for
my
review.
my lord,
And filed so such a long time.
my lord's bench was, my lord, it's an amnesty
review, huh?
application, my lord. My lord, it's an amnesty application, my lord will,
Only memo of review file.
my lord will kindly give me a chance, my lord will not, today again, there was a resolution, so my lord, I was on my legs, my lord will kindly not be that.
There is
hard.
no other side.
My lord, my lord, my personal, I was on my legs, my lord, before my lord Justice Showman Sen's bench, my lord will kindly,
Recall that order.
one, amnesty, my lord.
No, recall the order. Just adjourn it for.
I am indebted, man. I am indebted. I am indebted.